Truths and stories gotta collide. Alibis get swept aside. I got proof that can't be denied. The data don't lie, people do. Waves crashing, secrets in the tide. Facts and numbers side by side. Through the chaos I will abide. The data don't lie, people do. Look at the records, feel the vibe. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do. Friends may twist and tongues may tie. Plausible tales.
Hello, everybody. Let me get the chat on the screen. Getting myself organized here. Hey, chatters. So, hi, Brandy. Sorry, Randy. Misread that. Hi, Kelly Melly. Boda Bob. How's it going? Pauline Harkness. Nope. No sound? Oh my goodness. You can't hear me either. You can hear me now. You couldn't hear the music. Ooh. Well, here I was thinking I was being tricky, playing it through a non-ad browser. Did you hear the music? That's a bugger that you just sat there for like 4 minutes listening, like looking at a blank screen if you didn't hear the music. Okay, good. We're good. We're good. All right, let me pull this document. Shall we jump into this straight away or wait for a few more to join us? Let's have a look. Let's have a look, ski, what we got happening over here. Let's go here and here. Got a few buttons to play with. It's not actually showing me anything over there. Weird. Weird, right? What case? Karen Reed case. Michelle heard the music. All right, so it was just between the music and coming back after the music. Gotcha. Oh well. There's some weird shit going on here. And it's probably because I got so many freaking tabs open. Let me close a few tabs and things here. We can quit that and quit that. All right, so it is live. Yes, it's live. It is live, MCAT. Hey, big dog from Arizona. Hello, American Dreamer. I'm glad you were watching one of my previous videos. That's good. Started with the music and then went silent. Yeah, bugger. Hey, Alexis. Thanks for joining us. All right. The way to tell is it says live on the screen somewhere. It will tell you that it's live. It depends how you're watching it, I guess. But it's all good. Typos are good. All right, let's get this up on the screen. Let me find it. I guess I should open it first. It's a good start. I mean, maybe won't be opening it with that program. Let's do it. Let's do it with good old default previews app. And then we'll share the screen. Hopefully my eyes don't dick out on me today. It is white on black, and it does happen sometimes, depending on how much I've been working on white on black. Alright, so the denied video. Yeah, I realized when I uploaded it that I was saying yesterday, because I actually did record it yesterday, which made the actual hearing 2 days ago. But then I fell asleep halfway through recording. You'll probably hear the birds at some stage when I woke up and finished it. So, hey, Sassy Guinea Pig, thanks for joining us. I'm glad you caught us as well. I do sleep, but I just have a weird sleep pattern right now, which is not helpful. Thank you, Leeds in Shetland. That's very helpful. That's awesome. Miss Mandy reacts. Hey, girl. Thanks for the super chat. I don't know what that is. Is it a super chat or a sticker? It's one of the two. It's a super chat. I do know what it is. So hopefully I'm the first one. Usually, I wait for everybody else to get theirs out the way, but I thought, you know what? I'm going to do it. I'm just going to jump on it and do it. I technically should be doing something else, but that's okay. Let me change this around so that I'm not in the way. And you only got an avatar anyway, so, might just be, let's do this with no avatar, like that. Doesn't make it any bigger, does it? Let's see how this goes. That makes it bigger. Cool, we can all see it then. All right. So this is redacted to the crappers. All right. And it's like multiple pages that are just black, like lots of pages, but there is enough for us to get the general gist of what's going on. So essentially now comes the defendant, and respectfully moves this honourable court, pursuant to Article 12 of the Massachusetts Declaration of Rights, the 5th, 6th, and 14th Amendments to the United States Constitution, the exact ones that we've just been covering, right? And Mass Rule 14C, to dismiss all charges with prejudice on the basis of extraordinary, not ordinary, but extraordinary governmental misconduct. See U.S. Constitution Amendment 5. Blah, blah, blah. A prosecutor may strike hard blows, but he is not at liberty to strike foul ones. I love it. It is as much his duty to refrain from improper calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. This is Berger versus United States, 1935. Throughout the course of these proceedings, Miss Reed has been severely prejudiced, indeed she has, by the Commonwealth's pervasive misconduct. The Commonwealth has suppressed discoverable and exculpatory video footage. That was the topic of my last video, for those who didn't see it, from the Canton Police Department. It has provided piecemeal disclosure of some footage, most of which was disclosed after the last trial started, and after the Commonwealth presented that all video footage had been provided to the defence. For reasons that remain unexplained, much of the video that has been disclosed is missing critical timeframes and evidence central to Miss Reed's defence. We just covered all of this in my last video. So who in here type a 1 if you caught the last video? It's an hour long. I just uploaded it like an hour ago. If you came straight from my last video to here, then you're on it. Thank you, Sassy. I will. All right. So, thank you, Alexis. I'm glad people are getting some value out of this research, because, as I said in some of the previous videos, it's like climbing around in the dark and not knowing where you're putting your feet. Because I'm from Australia, I don't know American law. I don't know how it works. But I'm pretty sure most Americans don't even know how this works. A lot of people have been saying, oh, we don't know how it works either. So I'm glad people are getting some value from it, and it's helping us put one foot in front of the other without fear of a black hole, if that makes sense. So, but yeah, essentially the things that we're talking about here in the motion to dismiss so far is what I covered in the last video in some detail. So where were we? After the first trial in this matter, I missed a sentence. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. At the first trial in this matter, Assistant District Attorney Adam Lally brazenly introduced inverted video and elicited patently false testimony from MSP Sergeant Yuri Buchanek. I got it. I won't get penalised for saying the other word. That the video was a fair and accurate depiction of critical events. To falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the rear taillight of Miss Reed's SUV. I would have gone one further and said that they were trying to falsely insinuate that the jury was actually looking at that taillight. And, trying to give it the appearance that it looks brighter than it actually is. There can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defence by making it appear that MSP Trooper Michael Proctor was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was, in fact, standing directly next to the rear right taillight. Other other Sallyport video, which was unquestionably favourable to the defence because it would have severely discredited key witness Brian Higgins, blankety blank blank blank, inexplicably was not disclosed to the defence until months after the first trial. To this day, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Sallyport video and why some video was suppressed from the defence at the first trial has made a mockery of Miss Reed's right to due process. So I'm going to do the blankety blank 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 when we get to those because there's a lot of them. But I will try to fill in, if I think there's something relevant there that I think I can fill in, I will try to, but I don't know that was relevant. The Brian Higgins blankety blank, I don't know that that's relevant. Anyone have a guess? Want to have a hazard a guess what that is? Well, I'm kind of learning while I'm looking it up, Sassy. It's what's the term for that? Learning as you go, tripping over it as I find it. You seem like an expert. Yeah, I'm trying not to be. I'm trying to actually give the impression that I'm a lay person because I am. But there is. I think there's a certain gift, I guess, to looking up case law and then matching the case law to the case that you want to use it in, I guess. So I wouldn't say gift. Let's just say I got educated as part of my degree. So, hey, Sean, glad you called a chat. Thanks for dropping in. MCAT said it, not me. Higgy on the phone, you reckon that's what it is? Her first go at appeal was denied? No. I don't think I said her first go at appeal was denied. Well, SJC, yes. Her first go at the SJC appeal was denied. But she's also had a win in the SJC prior to that, though. I think that's how she got Jen McCabe's phone, because she took that to the SJC and won it. I think that was, I'm sure someone is going to correct me if I'm wrong. SJC was appealed. Correct. SJC is currently being appealed now in the federal court. But her first appeal would have been probably actually the one where she asked for Jen McCabe's phone data. That was actually not denied. That was allowed. So we're all getting confused because there's several of them. But right now, the habeas is in motion. It's not been denied or anything. It's not even been allowed right now. Right now, they're just assessing. I think they're having like a preliminary hearing on March the 5th for that. So this is indeed the request for dismissal. So this is the defense asking for Judge Canoni to dismiss this case again. Right. Hopefully I got this all in the right order. I've been so deep in the rabbit holes. It's sometimes difficult to pull back out of the rabbit holes and remember where we were at, 6 months ago or a year ago. So, yes, there is. If you look at any of my videos, you will see PayPal at the bottom of the description boxes. There might not be one in today's because I didn't book this live stream through the YouTube. I booked it through the Restream. It's confusing, but any of my videos that I've uploaded, just look into the video section, not the lives. You will see a PayPal donate link. So, but thanks for asking, Carrie. She does want this case dismissed, but who doesn't? Social Mail. Thanks for dropping in. Judge Bev doesn't want this dismissed. So All right, where were we? Eminem. We're at the bottom. Okay. Let's keep going. The Commonwealth exploited this court's order instructing the defence to disclose its impeachment material in advance of witnesses testifying. ADA Lally and MSP Lieutenant Brian Tully, huddled with key witness Jennifer McCabe mid-trial, prepped on how to explain why she never disclosed that she went to CPD Sergeant Michael Lank's house one day after John O'Keefe's death, and then suppressed exculpatories made by McCabe during that session until nearly a month after McCabe's testimony. We heard AJ going off about that actually in court, at which point McCabe and other relevant witnesses were safely off the witness stand. If the Commonwealth had complied with their obligation to provide statements of witnesses before they testify, the defence would have been positioned to expose McCabe's material inconsistent statements about her meeting with Sergeant Lank. Blankety blank blank. So obviously this is what came up a month later from her phone. As a result of this extraordinary governmental misconduct, Miss Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Miss Reed and the injustice of proceeding without the lost exculpatory evidence that was in the cops' possession, namely all these videos and the metadata for said videos. Again, I covered the metadata issue in the denial of the metadata in the last video. Accordingly, the case against Miss Reed must be dismissed with prejudice. Statement of facts. All right. Do we know what she's charged with? The Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withhold exculpatory evidence, and interfering with the jury. Yes. Yes. We have interfering with the jury has entered the dismissal. I was going to say chat, but it's here. Hey everyone. Hey Karma, thanks for joining us. Right, Bob, nothing to see here, right? But this is good. This is good. Interfering with the jury. Because in my last video, I speculated that this was retaliation for Karen going on TV and saying that they had interfered with the jury. So we are now out of speculation territory. In a case in which the jury either voted to acquit or was deadlocked on the lessers of one charge, there is no cure short of dismissal with prejudice that can remedy the serious constitutional and statutory violations that have occurred in this case. Let me read this first. In the days and weeks following the first trial, 5 deliberating juries have come forward and indicated that they unanimously acquitted Ms. Reed on counts 1 and 3 and were hung back to count 2. They indicated that they did not believe they were permitted to report the unanimous decisions on counts 1 and 3 unless they were able to reach a unanimous verdict on all counts. Ms. Reed's failure to address any claims of double jeopardy in the instant motion to dismiss shall not in any way be deemed or construed a waiver of those issues which are presently pending before the United States District Court for the District of Massachusetts, or the federal court. Talking about the habeas petition there. Okay, so the facts related to the respective misconduct and discovery violations are set forth below. Facts relating to the destruction and withholding of exculpatory CPT video surveillance footage. This court is aware of the critical importance of the video surveillance footage from the CPD on January without accompanying reports, evidence logs, or other document custody of this evidence on at least 4 separate occasions. So this is one of the motions that Judge Bev has just denied, where they were asking for these. And I did cover all of the remedies that were available to the defence, and it looks like they are taking the first step in remedying that situation because she denied it. So this is good. But the full gamut of what they can do, like if she doesn't dismiss, now they can move on to another level of appeal, and they can move on to another. They've got at least 3 levels after this, essentially. So it'll be interesting to see how she deals with it, because she's already dismissed that part. Relevant discovery orders. On February the 2nd, 2022, the defense filed defendant's emergency motion for preservation of evidence, including the preservation of all physical evidence, such as video surveillance footage, with the Southern District Court. That is an exhibit here, but I did see a copy of that circulating on X, and it is dated February the 2nd. So that was the first time she went to court. So you know how she was arrested the first time, then she got out on bail, and then she was arrested the second time, and that's when David Yannetti asked them to preserve this evidence. I think that's why. Actually, this might have been the first arrest, actually. February 2nd, because I think she was arrested again after that, wasn't she? I think this is the first arrest. So the order to preserve evidence was issued in the Stoughton District Court, and it wasn't by Judge Bev, it was another judge. At the February 2nd hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the District Court issued a preservation order for all physical evidence, which includes video surveillance footage. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession, custody, or control, which included the CPD and or Massachusetts State Police, and ADA Lally was required to notify law enforcement of this order. On September 16, 2022, after Miss Reed's case was transferred to Norfolk Superior Court following her June 9th indictment, there you go, that was the second one, the defense filed a separate motion to compel the production of certain outstanding discovery, including all crime scene photographs and all videos taken in connection with the case. And remember, their answer was, we lost the camera. Yes, she was. So it looks like it was June was the second arrest. Hello, Andrea. Thanks for joining us. And who have I missed? Cornpote. Oh my God, you got it. I did. Let me hang on. Who's my shout out to? Hal on X. I don't know who Hal is. Harley on X. Thank you for sharing that. Much appreciated. We got it. So that we got it. Hey go Georgia, thanks for tuning in. Beb shaking like a leaf after threats from, if she didn't get rid of AJ and the ARCA guys, right? I've actually just covered this all in great detail. Go Georgia, if you have not seen my last 6 videos, go and catch up, because I did cover her threats and all of the possible implications of getting rid of AJ and ARCA. Hello Cheryl with an S. Thanks for tuning in. All right, let's get back to this document. So we got that to see Exhibit B on order on defendant's motion to compel. On October 5th, 2022, this court granted the motion to compel in part and ordered that the Commonwealth produce all video evidence and metadata associated with the videos on that date. And then yesterday, a couple of days ago, she just completely reversed herself by denying the newer motions to compel. Dates of production and facts relating to discovery and constitutional violations. The CPD's video surveillance footage has been in the Commonwealth's possession and custody and control since January 29th. Blah, blah. What's the blankety blank in there? It's going to be Chief Helena Rafferty said blah, blah, I'll bet. I do remember she had something to say about it. I just forget what it was exactly, but I reckon that's her. She actually escorted John O'Keefe's mum into the courthouse the other day, so we know she wants her name hidden very well. So Sassy, I'm gonna have to catch up. Okay, that's fine. So, notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defendant 2 years, failing to disclose even the first incomplete batch of the footage until the eve of the first trial on April the 4th, 2024. The Commonwealth, before I do that, because I end up with too many of them, let's have a look at this footnote. All right, blankety blank, footnote. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the CPD on 29th of January 2022. April 4th production. On the eve of April 2024, the first trial in this matter, the Commonwealth for the first time disclosed woefully incomplete CPD footage, which consisted of video from the CPD main driveway and the CPD Sallyport front wall cameras from the 29th of January. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise moment the SUV arrived at the Sallyport garage. The missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the CPD Sallyport garage. And the individuals who had access to the right rear taillight, and whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement's custody is perhaps a critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2nd preservation order, which means that the defence has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost crucial video evidence in its possession that it was obligated to preserve. Oh, come on, guys, you ripped me off. Where is it? Oh, no, they missed the case law. I'm sure it's all here, but they missed the case law. I wanted to match it with the case law that I found, which is a bummer. So, what do we got? Sorry, I'm reading the chat now. So, greetings from Germany. Thank you so much, Milujo. I don't know how to say your name. I'm sorry if I'm mispronouncing, but hello, welcome from Germany. Glad you could join us. Go Georgia. What blows my mind most is with all the talk of intimidation and gaslight, exactly, by Hanky. And Bev has never moved. Paul, yeah, any other judge would have, right? Exactly. Glen Lake. Yes, Aussie redacted. Yes, of course. And hello, Karen Reed's not guilty verdict. Formerly Darla the human. Okay, I've got to remember to just say Darla because that's way too big a mouthful. Oh my God, you had to ask the hard question. What case law? All right, have a look here. Let me just read what it was that I said about the case law. Hang on. In violation of the preservation order, deleted, altered, or manipulated, otherwise lost crucial evidence in its possession. So case law for that will be, let me go. The implication of Judge Canoni's denial of motions for metadata, evidence logs, and expert oversight in discovery. So Brady versus Maryland, 1963, the prosecution must disclose all exculpatory evidence to the defense. And Giglio versus United States, 1972, the prosecution must disclose any information affecting the credibility of its evidence. And then the denial of the evidence by Judge Bev, denial of motions for chain of custody evidence, falls under Arizona versus Youngblood, 1988. The state must not suppress or destroy evidence that is material to the defense. California versus Trombetta, 1984. Defendants are entitled to examine original evidence for potential exculpatory value. And then denying defense oversight, so they could see what the police were copying, falls under Melendez-Diaz versus Massachusetts, 2009. Defendants have the right to confront the reliability of forensic evidence. And Crawford versus Washington, 2004, the Confrontation Clause prohibits the prosecution from presenting evidence that defense cannot independently challenge. And then that's pretty much it. Was that enough case law for you? Those are a couple of the ones that I found that support pretty much all of that. So that case law, sassy. Funny how hard Hank is trying to tell everyone that he's not trying to get rid of Arca, but he is, isn't he? He's just trying to get rid of Arca. I mean, it's pretty obvious. I'm catching up. Yes, I've been getting plenty of sleep. I, in fact, started the video I uploaded yesterday, the day before, and fell asleep on my keyboard. But I did sleep a good 12 hours. So, meta jail time. Exactly, Glenn. She does. The Commonwealth has a non for it. Yeah, don't they? Don't they? Oh, they got their own team. Just remember, they've got 2 highly qualified appellate lawyers who have their own teams working on this, who are way more versed with these laws than I am. So, but there you go. That's the case law that's related to this that they've just mentioned here. But on top of that, there's probably more case law because they are actually violating a preservation order on top of all of that. So I'm sure there's more that is applicable here. Thank you, Tony. Thanks for tuning in. Love from Southwest Florida and on the Gulf of America. Oh, on the Gulf of America, sorry. Thanks for joining us. It's common practice by American law enforcement to allow Axion BWC, a body-worn camera video, to automatically be deleted when police use force or wrongfully arrest. You know what? But they even, I don't even think any of them were even wearing their body-worn cameras. It seems to appear like they weren't, or they destroyed all of evidence of having worn it. So, okay, so let's move on with this. On April 10th, 2024, the Commonwealth files its Certificate of Compliance, in which ADA Lally certified to this court 6 days before trial that the Commonwealth, after exercising reasonable inquiry and due diligence to the best of their ability, disclosed and made available all items subject to discovery. This representation was patently false. It strains credulity. Someone's been listening to Melanie Little. Do you think that, hang on, I'll work out who wrote it at the end, but do you think they've been listening to Melanie? It strains credulity is definitely hers. It's a great little phrase. It strains credulity. And they even miss some case law in their motion. And yet, well, I don't know if they did, because I'm not up to the appendixes and crap. So it's probably in the appendices somewhere. Bob says no, but I think the cameras in and around CPD are Axion video. Yeah, right. I think they are too. Only at her second arrest. I think you might be a little bit behind us, but thank you for that. Let's continue on then. It strains credulity that ADA Lally, in light of his actual knowledge about the preservation order and existence of extensive Sally Port video, would represent to the court and to the defence that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody and control. At a minimum, rather than mislead the court and the defence, ADA Lally was obligated to inform the court and the defence that there was outstanding video surveillance footage. So under Mass Rules of Professional Conduct 3.4d, party may not fail to make a reasonably diligent effort to comply with and legally proper discovery request. I also got 3.4d in my research, because it goes on to say, let me find that, 3.4 also 3.4 also says that explicitly 3.4g explicitly allows reasonable compensation for expert witnesses' time and expenses and reimbursement for travel and accommodations. But there's also no, that was it. I think it was only, B, 3.4b says that attorneys are allowed to reimburse expert witnesses for expenses and time, and it's obvious that's going to be after the testimony. Like, you can't pay them for time they haven't submitted yet. So obviously it's after testimony. Anyway, Sassy says, let me give you compliments on the amazing research you've done. Thank you, Sassy, which is exactly what you have been doing. I've been trying. I've been trying. But the reason I was excited to read this is because I wanted to see how what I'd researched matched up with what the defense was already looking into themselves. So, so this is kind of like a proof is in the pudding kind of test. Because you remember, these guys are experienced appellate lawyers. They know what they're talking about. I'm just a little layperson here with a bloody, a fancy Google. Okay, C, April 23rd, 24, the Commonwealth, 2024. The Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Miss Reed's SUV. Blah, 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 Helena Rafferty. That's what that blankety blank 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 says. We miss footnote 3. ADA Lally was cognizant of other disfavourable material that the Commonwealth did not disclose before certifying his compliance with the obligations. Notably, when filing the certificate of compliance, he expressly represented the lone exception of outstanding discoverable material was evidence related to DNA testing. He did. Indeed, he bloody did. Indeed, he did. Helena Rafferty. Blankety blank blank. On the 23rd of April 2024, the Commonwealth produced additional footage from the CPD Sallyport backwall via a share link entitled Additional Sallyport Video Download Link. No flash drive was presented to the defence. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as a part of their attempt to convince the jury that nobody approached or touched the right rear taillight of Miss Reed's vehicle after it entered the Sallyport. ADA Lally, there's too many Sallys and Lallies and taillights, and all these L's are getting my tongue all tied. ADA Lee craftily elicited testimony from Sergeant Buchanan that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the rear taillight. While I'm tripping over those L's, let me just say that yesterday when Attorney Alessi said, what were the two words? Elucidate and illuminate. I wet my seat. That was so good. I went from this guy's pretty darn top appellate lawyer to, hey, you should marry my daughter, dude, and become my son-in-law. Just because of those two words. No, it was his presentation. Like, he kicked it out of the park, didn't he? So Glenn Lake says, patently false is a nice way to say you're lying through your teeth. Exactly. Yeah, these videos lately, Aussie, have been off the wall. You were working so hard to get this info in. We thank you. Well, I'm glad people are appreciating it. And I'm glad it's, educational. It certainly has been for me. Very educational. So, where were we? On cross-examination, Sergeant Buchanan's testimony was exposed as profoundly misleading at best, perjurious at worst. Perjurious. I hate it when they come up with words I can't pronounce. I think it's perjurious at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. Critical facts which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or jury. In other words, this video made the left side of Miss Reed's SUV appear to be the right. Footnote: for Commonwealth never filed a supplemental certificate of compliance. A bit of bat flattery happening here. Made the left side of Miss Reed's SUV appear to be the right and the right appear to be the left. Therefore, the video presented to the jury was as fair and accurate, appeared to show a person, Trooper Proctor, standing near the left rear taillight of the vehicle when in fact Trooper Proctor was standing near the right rear taillight, the very taillight at issue. Moreover, the inverted video does not capture the condition of the right rear taillight, and it conceals Trooper Proctor's presence by the right rear taillight. This leads to the inescapable conclusion that ADA Lally's questions, Sergeant Buchanan's responses, and the deliberate introduction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and misread with respect to a critical issue in the case. On October 10th, 2024, the Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. So October is like way after trial's finished. Post-trial, the Commonwealth again provided new footage, at this time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. Wow. 1, 2, 3, 4. There you go. This footage shows Higgins arrive in the parking lot at 1:26 a.m., enter the building, and speak to some unidentified individuals on the phone as he is leaving at 1:34. Significantly, this specifically requested material and relevant evidence which establishes that Higgins was on the phone with some unidentified individual at 1:34 as he left the CPD shortly after O'Keefe's death, was suppressed until after the first trial by Helena Rafferty. I know it's her that they're trying to protect there. It's pretty freaking obvious who they're trying to protect in those bits, because she's the one who has, the last say over all that rubbish. So, Sassy, you enjoyed watching Alessi too? I'm still stunned that she denies them the metadata. Same here. How can you deny them evidence and get away with it? And here's the stunning thing, is that she's actually an administrative judge. She administrates, like, she's supposed to know, and she's also, I can't remember, it's some sort of administrative role on the bar as well. I can't remember the exact titles for it, but she knows about evidence handling. She knows about metadata. She knows about digital evidence. She knows all this shit because she helps them write it. She knows it. So pretending like she doesn't know that she has allowed inadmissible evidence into trial, pretending like she doesn't know that that's flies in the face of reality. And Hank's not that dumb, no, exactly. Wayward Thought by Corn Pope. The video of 34 Fairview existed. I'm convinced they told the press in the first days it did, and I think it really did, and it disproved their case. Right, so I think this is the missing minutes from the library footage. That's what I think it is. Canoni has egregiously failed to administer justice fairly. Indeed, Super Squirrel, and thanks for joining us. Videos do not invert themselves. Well, you know what? They actually do, but even if it was recorded inverted from that camera, the timestamps would not be inverted, if that makes sense. So it's confusing, because when we tested it and we inverted it, like when we tested it on one of those cameras and we inverted it, the timestamp stayed the right way. But when we turned it back the right way, the timestamp was still the right way. But the problem that the defense had was they were given a copy of it. They weren't given the exe file that goes in the program to see what the setting was, basically. This is part of, I guess, the metadata that would have gone with that exe file, and that would have told them then whether it was inverted in while it's sitting on the wall. Sometimes when you put your camera upside down, you need to invert it, obviously, because your camera's upside down. So if you're going to stick it to the roof, for example, or if you're going to stick it to the wall, or if you're going to stick it in a different, I don't know, position, sometimes you do need to flip it and invert it and do all these different things. And I don't know, I think some cameras actually do have like our phones do, like they know when they're being tilted and tipped. So some cameras actually can detect that and do the inversion themselves. So there's also that, depending on where the camera was actually located. But because it was on the wall, I don't think it flipped itself. So in that sense, I think Glenn's right that it wouldn't invert itself because it was on the wall. And then obviously the timestamps don't invert themselves exactly. What's Dawn? Thank you for dropping by. Another lawyer I listened to said the defense has made a grave error by not including case law in this argument. I guess we'll see. As you say, the defense has 2 appellate lawyers. Yeah, I'm going to look through attachments just to make sure that they're not in attachment though. Bev's dad was a bigwig in Norfolk County judicial system. Why does that not surprise me? Clearly biased, exactly. I stand inverted. is crazy. It's crazy. Hang on, let me get it up on the screen bigger. It's crazy that this stuff seems par for the course now. I'm not even shocked anymore. No, me either, Cornpape. It is crazy, right? I hate that I'm not shocked. I just expect this. Oh, well, this is what I love. It gives me something to, when I actually go down these rabbit holes and research, it gives me like so much to look at. It's not like I've got to dig really hard to find something because it's so common now. Glenn, it's okay. You were kind of right. It's all good, mate. Anyone else knows how Hank deliberately keeps mispronouncing Alessi's name? Yes. Well, he's probably having a go at us because we deliberately call him Mr. Breenan. So it's probably snark, I guess. Somebody put the timestamps on the flip video. Well, right. And here's the thing, James. Thanks for joining us, James, by the way. Here's the thing, James. What we found with our playing in that software, with the Equivision software, is that all those timestamps that have like a shadow behind them or a glow behind them, that stuff's not part of the software. So those timestamps absolutely were put on afterwards. So firmly established. Yes, it's a security camera, exactly. Good evening from Scotland. Thank you, Alba, for joining us. This case totally blows my mind, and the bias from the judge is so blatant I can't fathom how anyone can say Karen is guilty. Right there with you, Alba. Auntie Bev's fait accompli. Thanks for joining us. And yes, I'm in agreement with you. Sorry, I'm in agreement with Alba. And thanks for joining us, Auntie Bev's fait accompli. He's a bit mixed up there, didn't I? I love and respect all of your work. Thank you, Karma. Much appreciated. Let's continue on the mission. The Commonwealth failed to preserve exculpatory video surveillance from January 29th in violation of court order and Brady versus Maryland. On November 8th, 2024, while preparing for Miss Reed's second trial, this is more recent, and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, Attorney Elizabeth Little emailed Special District Attorney Hank Mr. Breenan, again requesting inter alia All raw footage from the CPD, which shall include but is not limited to all cameras capturing the interior of the CPD and or the exterior of the CPD, including all parking areas, entrances and exits and garages between 29th of January 12 a.m. and 29th of January 11:59 p.m. On November 25th, 2024, ADA Brennan indicated via email he would request the CPD provide all requested footage. Ultimately, the defense requested access to the CPD DVR system and drives that hold the recordings from the security camera system so that defense expert Matthew Erickson could obtain video files and corresponding log files from January 29th between 12 a.m. and 11:59 p.m. Upon reaching agreement with the Commonwealth, Matthew Erickson visited the CPD in the morning of December 12, 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Ms. Reed's case via standard forensic protocols, as they were obliged to do pursuant to the February 2nd preservation order and October 5th order compelling discovery of all videos and related data. January 28th, 2025. The Commonwealth produces more exculpatory blurry video surveillance. Is anyone surprised that it's blurry? Establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Sallyport garage. Holy, is this new? This is new. He didn't mention this in trial the other day, or did I just not hear that part? I don't know. Tell me if you guys heard. Is this new? Thank you for becoming a member. Karen Reed's not guilt. Darla. Thank you, Darla, for becoming a member. From Alessi. And you're watching DUI Guy. He's pretty good, eh? He was saying that he didn't know that this type of law still existed, and it's now difficult for Bev to remove Jackson. That's right. It's impossible. She can't remove Jackson without causing an immediate interlocutory appeal. Did I decide that it was interlocutory? I forget now what I decided. One of those appeals. But yeah, she can't remove Jackson without causing an appeal. So yes, truth is I didn't go to bed. Oops. Thanks for coming and joining us. Hello, Sunshine. Thanks for tuning in as well. So I think there's new information because I actually recall this coming up during Bev's back out hearing. Do you guys remember it coming up? I remember them saying about the Higgy video, but not this one. Blurry video surveillance footage of an unknown person. Interesting, right? So on January 28th, 2025, the Commonwealth yet again turned over CPD surveillance footage from January 29th, this time from an exterior camera depicting Miss Reed's SUV being brought into the Sallyport garage, main driveway, side exterior Sallyport. Look, this one's an EXE. That means that it's actually from the Equivision software. I don't know if you guys noticed this, but during trial, they were showing lots of different things. They were showing MP4s, and I think even one of them was like a Windows. I can't remember the extension for Windows videos, WMF or something. So yeah, this was really odd because if it all came from the system, it had to be EXE. The footage, although blurry and grainy, upon individual approach the right rear taillight of Miss Reed's SUV, immediately after the vehicle is brought into the Sallyport garage, and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear tail light as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs, or becomes grainy at the precise time of the right rear taillight of a Lexus SUV should be in frame upon its arrival at the Sallyport. And the reason it defies logic is because it's their freaking story that the taillight was broken when they got it. It's their story. So why is all that video missing? This angle of the video surveillance is exculpatory and was withheld from the defense prior to the first trial. It's their story that it was broken. It's the defense's story that it wasn't. So it's exculpatory to the defense. It's inculpatory for the Commonwealth. So it does defy logic that if it supported what the Commonwealth says, they would hold it back. They would withhold it. So clearly it doesn't. Mandy, I think it's new. Thank you. I think it is too. Give me 1 sec to have some coffee. While I read your comments. It is new, Alba. Thank you. I'm thinking it is too. Thank you, Trebor. Trevor. Don't know how to say your name. Hopefully I got it close. Thanks for joining us. Super Squirrel says, given CPD is recused, numerous CPD personnel entered both Sallyport and the perimeter established by crime scene tape. Exactly. Exactly. James says, I think I heard Jackson talk about this a week or so ago. The outside, well, he did speak about the outside camera where it caught Higgy walking around on the phone. I don't remember hearing this about the extra blurred right rear. This is a different camera, completely different camera. So I got let me see if I can help reorient you in with the cameras. All right, we got the reversed footage came from the camera over the police car, the really old police car. So the camera there on that wall, and then on the very opposite wall to that, towards the opened door, there is another camera, and that's the one that was all just fuzzy. There was nothing, we didn't see anything with it. It was just fuzzy, but it wasn't always fuzzy. It's that same camera that originally we saw that really black darkened footage. So in one bit of footage, it's really dark and darkened, contrasted dark. I tried to lighten that and uploaded it for you guys to see what it looks like with all the contrast and brightness brought back up. So there's that camera, but in one instance you can still see some stuff happening there. It's just really dark. But in the next instant, they've produced camera footage from that same camera, and it's fully fuzzy, like the test pattern on a channel that's not actually connected, TV channel. It's fully fuzzy like that. So the next camera that we know of is actually on the outside where the driveway is. We saw the tow truck coming in with Karen's car on it, so there's that camera there as well. So the one that we haven't seen any footage from yet has been this one over the car park itself, and that's what AJ was saying. Was it AJ? I forget who said it. That's where they were saying there's now footage of Higgy, and now this one is back inside on the fuzzy camera on the opposite wall to the police car. So hopefully that orients you with all the freaking cameras. But there's actually more, because in that previous section we just read in this dismissal, it was there's some hallway or corridor camera footage. So there's a lot more that we haven't seen, but those are the main cameras that I can recall off the top of my head. Okay, facts relating to the Commonwealth's intentional withholding of exculpatory statements made by seminal witness Jennifer McCabe. Oh my God, this woman's turning out to be the biggest butt pain of the whole trial. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's defence. On the 2nd of February, mere days after O'Keefe's death, the MSP obtained and forensically imaged McCabe's cell phone. This is one of the SJC appeals that they won, I think, because Bev said no, and then they went to the SJC to get it. The forensic examination of McCabe's cell phone reveals significant exculpatory evidence supporting Ms. Reed's third-party culpability defence. Inter alia, establishing that McCabe Googled how to die in the cold on January 29th, 3 hours before she supposedly discovered, quote unquote, Mr. O'Keefe's hypothermic body in the snow on her brother-in-law Brian Albert's front lawn. McCabe then took steps to delete that watch out of more than 4,500 on her phone, along with nearly every communication made on her phone in the hours following O'Keefe's death, only which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between the Albert and the McCabe families and the law enforcement officers assigned to investigate this case is central to Miss Reed's third-party culpability defence. Let's check what's going on in here. Yay! Darla gifted a membership. Alba, you are the winner. And then another one. Bam! Off she goes again. Coffee cake. Bam! You are a winner. Thank you, Darla. Thank you kindly. Yes. And did I miss one? Oh, I missed one. Coolies. There you go again. Darla gifted James. Notably, Super Squirrel says noteworthy Gallagher directed alteration of physical evidence. The Lexus, under what authority did this manipulation occur? How now discredited Proctor was in the Sally Port. So you're talking about when he said they pulled the taillight out of the car, complete, like the whole unit, the whole assembly out of the car, and some of it broke. I think what you're talking about. Where are we? Right. Holy cow. Holy cow, I won the membership lottery. Yippee. Welcome. Brent Mack. Hey, I don't know if anyone, thanks for joining us. I don't know if anyone else has brought this up, but just before you went live, Truth and Transparency ran a live showing Matt wrote, yeah, but it's not really based in reality. It's okay to speculate. I'm fine with speculating, but I like to stick to the facts here. Thank you for the gifted membership. Was thanking Darla for the gifted membership. All right, so let's continue. Sergeant Lank, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th. In preparation for trial, the defence uncovered location information on McCabe's cell phone, which proved that she went to first responding Officer Sergeant Lank's home on January the 30th, the day after O'Keefe's death. Helena Rafferty. I don't know if that's actually related to her, to be honest. It's blankety blank blank. All right, let's think about this. It's obviously what was on Jen's phone. This is what we're seeing here, what was actually on Jen's phone, essentially. On May the 7th, in accordance with this court order that parties disclose all information to be used for impeachment purposes, Attorney Little emailed ADA Lally and ADA McLaughlin to provide location information from McCabe's cell phone, establishing that she went to Sergeant Lank's house on January the 30th, 2022. Unbeknownst to defence, ADA Lally and ADA McLaughlin shared this impeachment information with Tully. Not surprised. Are we? Nobody is surprised. I'm sure nobody's surprised. Are you surprised, James? I'm not surprised. James gifted a membership. Thank you, James. And Carolyn, you are the winner. You received a gifted membership from James. Hello, Diana. I'm glad you found the channel too. Okay, so Dawn says, I appreciate all the effort you put into this. Thank you for appreciating it. It definitely helps to see how this entire trial process is being conducted. Right. So without my research, you guys would just be sitting here in the dark, not knowing what to expect in this. And so because of my research, none of this is a surprise to anybody, right? So I'm glad you all appreciate it. All right, let's continue where we were. On May 10th, in a then undocumented meeting, Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's material. Hang on. Stop. Mouthful of coffee. We're getting tongue-tied again. Okay, let's go again. McCabe's materially inconsistent statement about meeting Sergeant Lang was not memorialized in any report or otherwise disclosed to the defense in advance of McCabe's testimony at trial, in violation of Brady, Giglio, and Rule 14. So I have quoted Brady, Giglio, and Rule 14 incessantly throughout all my videos. They're all applicable here. McCabe testified beginning on May 17th during cross-examination on May 21st. She testified that she received a text from her sister Nicole Albert stating, "We'll get more info tomorrow. Don't want to text about it," to which she responded, "Right." When Mr. McCabe was asked whether anything significant happened the next day, McCabe volunteered the following story. "I went to the O'Keefe's house. On the way home, Miss Kerry Roberts' daughter is good friends with Michael and Bubba." We know the freaking story she came up with. Such a liar, and she just makes me mad. I don't even want to read her words. Grrr. She testified that she was at the house for approximately an hour and that she might have gone in to go to the bathroom, which is a lie, blankety blank blank, lie. On cross at trial was the first time Miss McCabe mentioned going to Sergeant Lang's home on January the 30th. When pressed further, she admitted that she had discussed this issue at a meeting a couple of weeks prior at the DA's office. She testified at the meeting at the DA's office. I was asked, "Oh, were you at Mike Blank's on the 30th? She admitted that, "At first I said, no, I've never been to this house, and I thought about it, and oh my gosh, I lied, because I'm such a lying liar from Liarsville, ... She further testified that, 1, Tully did not ask her to any follow-up questions about why she went to the personal home of Sergeant Lank the day after O'Keefe's death, and 2, that he did not take any notes. On May 29th, only after the defence was deprived of the opportunity to effectively cross-examine McCabe and Kerry Roberts about the visit to Sergeant Lang's house, Lieutenant Tully memorialised his meeting with McCabe. Yeah, because he got busted. He got busted in the act, essentially. This is referring to all the exhibits. Tully's May 29th report, which also omitted any reference to McCabe's exculpatory statement, in which she denied that she ever went to Sergeant Lang's house, was not disclosed to the defence until June the 4th, 2024. This is lie, I got busted report. Lie, I got busted. Yep, busted, red-handed. Yours sincerely, Tully. Let me just check on chat before we go on. You and Melanie Gord. It takes a lot to be up there with Melanie Little, but I appreciate that. Thank you, Darla. She's a talker, right, Bob? Indeed. Exactly. Don't tell about it. Don't text about it. Exactly. Did anyone see that story by Sean McCabe before he went off the rails with JM's neighbour? Crazy stories like how she thinks she can brainwash anyone. Sean McCabe. You're talking about the fence incident or something, right? Had a bet. Yeah, I remember this being spoken of on X. So she made a bet that she could make anybody do what she wanted. So Squirrel, you can be certain that both Reed and Defence are noticing your research. To be honest, Super Squirrel, I think Defence are pretty sorted in the appeals department. I'm not doing much that they're to appellate very well decorated dudes, I might add, and their team are doing so much better than I appreciate that you have so much confidence in me. But question from Mandy Ridden. Ozzy, has this been redacted because it could taint future jurors? I think the redactions, let's just remember that it's the Commonwealth here. So if there's crap in here they don't want, like, for example, any mention of Helena Rafferty, obviously she doesn't want that shit out there. She doesn't want to be, publicly called out for her role in any of this. She's pretty much flown under the radar. So obviously hers is going to be redacted. But most of it, from what I understand from the motions that the defence put in to have the redactions done, it was names, phone numbers, sensitive material, confidential material, stuff that the FBI had already said should be under seal. So that sort of stuff. So that's what I think most of this is. But with the FBI's stuff is like pages and pages of just plain black. Like, I don't know why anybody wasted the ink printing black pages, but oh well. Sunshine, thanks for joining us, says, this case will be one for the books to be studied and used for case law. I agree entirely. So, Carolina, thanks for joining us. Definitely up there with Melanie. Well, I appreciate that. Melanie is my favourite watch of all time. Always go to her first before I watch anything else. So I'm totally on the same page with you guys. Alessi is amazing indeed, Caroline. All right, let's continue on. We are in the argument phase. So we have covered a lot of arguments. So in the argument phase, we do expect to see a lot of case law at this point. So the Commonwealth has engaged in numerous Rule 14 discovery violations and constitutional violations under Brady versus Maryland and its progeny. Misreads constitutional rights to effect assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments to the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. See Article 12 of, yeah, got it. These are the same things, they're just quoting it like the way you got to quote it for legal documents. So, defendants have an unquestioned right under the 6th Amendment and Article 12 of the Massachusetts Declaration of Rights to obtain relevant evidence that bears on the question of his guilt or innocence or which otherwise helps his defense. Pursuant to Brady versus Maryland and its progeny, defense counsel is entitled, as a matter of due process, to all evidence that is favorable to the accused and a material. So when you see it in inverted commas here, it's quoting from Brady versus Maryland, and material either to guilt or punishment, including impeachment evidence and evidence necessary to place the witness in his proper settings and put the weight of his testimony and credibility to a test. United States versus Bagley, 1985, and Alford versus the US, 1931. Brady disclosure also extends to disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. Kyles versus Whitley, 1995, citing Lindsay versus King, 1985. I think we covered Kyles versus Whitley in some of my research as well. In addition to her constitutional rights, Miss Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts Rule of Criminal Procedure clearly state that the Commonwealth must provide certain mandatory automatic discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its mandatory discovery obligations. Massachusetts Criminal Law 14A1A as amended in 2005. Information subject to mandatory discovery includes all material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or scientific tests or experiments, and statements of persons the party intends to call as a witness. The Commonwealth is also required to provide any facts of an exculpatory nature. The rules also state that the defendant may move for discovery of other material and relevant evidence not required by subdivision 1A. Here on February 2nd, 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage, in Stoughton District Court. Subsequently, on October 5th, this court ordered the Commonwealth to produce all videos in connection with the case and associated metadata. Notably, this prosecutorial duty to provide evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police. Rule 14 says the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case. So that's what Rule 14 adds. But then we've also got Commonwealth versus Sleeper 2002, quoting Commonwealth versus Chickery. That was one that I uncovered in my research, the Chickery 1992. A prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and presentation of the case. Commonwealth versus Beale. I don't know that one, but I do remember Graham versus District Attorney for Hampton. I actually did quote that one. It was very close to what happened here in this case too. So yeah, we were on the money with those ones. So that's good. See reporter's notes. So it's interesting to note that the reporter's notes give a little bit more detail than the actual text itself does. This provision requires the prosecution to provide automatic discovery of any facts of an exculpatory nature. It derives from the constitutional requirement established in Brady versus Maryland 1963. There you go. That the suppression by the prosecution of evidence favourable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. This duty is also an ethical one, imposed on the prosecution by the SJC, Rule 307. Hang on, Rule 3, Number 7, 3.8D. Internal citations and quotations omitted. There you go. Copy break while I read the chat. Yes, indeed. Most of them were. Hi, Ellie. Thanks for joining us. They were redacted by the defense. This is very sad, Laura. Thank you for joining us. They are bankrupting. Yes, they certainly are. It is very sad. Well, I'll take it now, Sassy. I'll accept the pat on the back. Okay, would you like me to apply the pat on the back as well? Here we go. Well done, Aussie. I'm just very excited to see that I was over the target. Like, it's good when you have some way to test yourself. Let's put it that way. So this has been a test of myself. I went and found all this stuff. Was I right? Damn right I was right. Well, pretty on over the target with most of it, hey? So it's good to test yourself, and it's good to have a way to work out the results, of testing yourself. So the Commonwealth's production of the April 23rd, 2024 inverted video from the CPD Sallyport garage violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence. First, the Commonwealth violated Rule 14 and this, okay, we just said that, by withholding the inverted video from the Canton Sallyport until after the start of trial and after the Commonwealth had already filed its certificate of compliance on April 23rd, 2024. At best, the inverted video had been in the Commonwealth's constructive possession since January 29th. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear taillight of the defendant's SUV upon its arrival in the CPD Sallyport. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it had filed its certificate of compliance violated Rule 14. Point 2. The Commonwealth violated Rule 14 and Brady by withholding exculpatory impeachment evidence establishing Higgins was speaking to some unidentified individual on the phone at CPD at 1:34 a.m. on January 29th. What time was the butt dial? Anyone remember what time the butt dials were? Did I just completely gloss over the fact that the butt dials were at the same time? I think I did. I thought that, hang on, the butt dials were at 227 was the Google search. The butt dials. Guys, this is the butt dials, isn't it? I don't know why that went over my head till just now, but it did. It's the butt dials. Tell me I'm right. The butt dials at 2:22. Okay, thank you. I actually made a video of that timeline. Like the order that everything happened in, but I just don't remember what I put in the video. So thank you. 2:22. So an hour earlier, he's on the phone with somebody. What's the significance of 1:34 a.m.? Karen's been home for an hour. So she's logging on to John's Wi-Fi at 12:36. So Karen's been home. What's the significance of this? Thank you, Ellie. I appreciate that. Gotcha, Glenn. On it. Albert. Thank you. I knew you guys would know. What is the likelihood of all parties making mistakes that could impact the outcome of it? It's statistically very low. Exactly, Sunshine. There's no reliable data tracking such a scenario. It would be statistically very low, I imagine. So I don't remember anything relevant at... I'm going to have to go over my timeline videos again to see what was relevant at 1:34 a.m. So let me just make a note of that so I remember to do it. All right, we're good. Well, let's continue reading this. All right. After trial in this matter on October 10th, 2024, the Commonwealth produced previously withheld video surveillance from CPD's church side exterior and rear lot cameras. So there's two more cameras, church side exterior and rear lot, which is the car park, I guess, which show inter alia Higgins arrive in the parking lot of the CPD at 1:26, enter the CPD and speak to some unidentified individual on the phone as he is leaving the CPD at 1:34 a.m. ADA Lally and ADA McLaughlin suppressed exculpatory impeachment evidence. And blankety blank blank, we're going to kick your ass. Blank blank. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. This falls under Commonwealth versus Harwood. That's not one I came up. I don't remember that one. 2000. Quoting Commonwealth versus Neal. That one I did. Commonwealth versus Neal, 1984. So there you go. This is a precedent quoting a precedent, just so you know what that's about. This exculpatory video surveillance footage was in the Commonwealth's custody and control since January 29th, and at the time of trial was in ADA Lally and ADA McLaughlin's actual possession. Holy crapola. They had it the whole time. By withholding this exculpatory evidence and failing to produce this information until after trial, Lally and McLaughlin violated Miss Reed's constitutional rights as set forth in Brady versus Maryland. Wow, this is so direct a Brady violation. so direct because they had it, because a prosecutor had it in their actual possession. Holy crap. All right, that one's big. See, I wouldn't say it's less of a violation. It's just, I don't know, it's got less weight if the CPD hadn't and had it, but they didn't hand it over. Then Lally's got, ignorance on his side. I didn't know they had it. In this case, this is blatant. This is, they did have it. CPD had handed it over, and it was a strategic play or move during trial to keep it here. So this is crazy bad. Crazy bad. This is absolutely prosecutorial misconduct. That's what I'm trying to get at. The Commonwealth violated Rule 14 and Brady by withholding exculpatory video surveillance footage establishing that an unidentified person had unfettered access to Miss Reed's right rear taillight of the SUV immediately after its arrival in the Canton Sallyport garage. Make me repeat that again. Just last month, the Commonwealth provided additional CPD surveillance footage, this time from an exterior camera depicting Miss Reed's SUV as it was driven into the Sallyport garage. This camera angle should have had a clear and unobstructed view of Miss Reed's taillight as it was driven into the Canton Sallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of the taillight. Notwithstanding that fact, the footage is exculpatory and shows an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sally part and then exit shortly thereafter. This video surveillance footage has been in the Commonwealth's possession since January 29 and was withheld from the defence for 3 years and only produced after trial. This video surveillance footage directly contradicts Sergeant Buchanan's false testimony at trial, in which they could have used it to impeach him, in which he claimed that video surveillance footage established that no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. Miss Reed's defence at trial in this matter was that law enforcement removed the taillight from the Lexus SUV and planted the evidence at 34 Fairview Road. Notably, no taillight material was found at the crime scene until after the Mass State Police took custody of Miss Reed's vehicle and after it arrived at the CPD Sallyport. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. This is Howard quoting the Neal case. And then as such, 88 Lowey and 88 McLaughlin violated Miss Reed's constitutional rights as set forth in Brady. So if that was in their actual possession, again, it's the same thing. It's not something they can claim ignorance of. As set forth by Brady, yep, we got that. And it's progeny, the criminal statute, and then SJC, and then withhold. Yep, gotcha, all that. Radio. The Commonwealth failed to preserve exculpatory evidence in violation of a court order. Oh man, this is nuts. Because they haven't actually got an excuse. If they said, yeah, exactly, Glenn, caught with their pants down. They said, well, the CPD didn't give it to us. They had actually half a legitimate excuse, but they don't even have that. They got nothing. They have absolutely nothing. And so in the last video, hey Libby, thanks for joining us. So in the last video that I just uploaded, we talked extensively about oh my god, my mind just went blank. What did I put in my last video? We talked extensively about this in the last video. about what could excuse them from having, what sort of excuses they could have. And we came down with what they got no freaking excuse. But they could say, even if they said the police had it and we didn't know, they're still responsible for that. But this is even more direct again. So it should be criminal, James. I completely agree. That right there, Sassy says, shows she shouldn't be going through it. Exactly. And that's the other thing that I covered in the last video too, was she won't sanction the prosecution for these violations. She has not applied a single sanction. She knows all of this. She knows they had all of this. She knows it. But she's not applied a single sanction to the Commonwealth for any of it. And that shows that she's biased. So, hi, Connie. Thanks for joining us from North Texas. And their exculpatory butts are on fire. Right. Exactly, Caroline. And the prosecutor planned to use the Sally Port video to show the taillight was broken. And the video was manipulated to make the left taillight look like the right. Exactly, Bob. Exactly. It was white. Exactly, Bob. The defense has not put this in here because I think it's a little harder to prove that they've doctored the color of the lights. Utterly evil indeed. Holy, this is wild, right, Alba? None of the evidence has chain of custody. Right, none of it. Exactly. And she has never once sanctioned anybody. And so the fact that the defense got sanctioned like twice, and now she's even considering a third sanction, with the ARCA guys. I don't know if you saw my last video, but I just explained how double jeopardy also applies in that case, like in the context of the witnesses already having been sanctioned for those witnesses and those Rule 14 violations. The fact that she's considering sanctioning them again for the same witnesses, that falls under double jeopardy as well, which is something new I didn't know before I went down that rabbit hole. But the fact that there's an inequality, she won't sanction the Commonwealth, even though they are doing way more egregious failures to way more egregious violations is what I was after. Way more egregious violations than them. So that shows that she has extreme bias and that she's trying to help the prosecution. Right, the buck stops with the DA's office, correct. But with respect to what I'm talking about now, that buck stops with Bev. So they're both on the hook now. Both of them. Prosecution withholding and manipulating, altering, and present during trial is beyond reproach. Indeed it is. So Bev should lose her immunity. She should. Some of this stuff is way beyond the pale, right? She absolutely freaking should. Okay. Clevin even believed the inverted. I know, that was so funny, wasn't it, Alba? He's sitting there watching the video, just as we were all watching it along with him, going, "Oh my God, look at the broken taillight." That was pretty funny. Right, sunshine. One should not negate the other. Indeed. All right, let's continue on. Okay. The Commonwealth failed to preserve exculpatory evidence in violation of a court order. So the CPD and the Norfolk County District Attorney's Office failed to preserve material and exculpatory video surveillance footage and associated logs in violation of the Stoughton District Court's February 2nd preservation order and this court's October 5th order compelling the discovery of all videos. Blah, blah, blah. Moreover, the metadata and log files underpinning the CPD surveillance footage from January 29th are clearly exculpatory, and thus the Commonwealth had a constitutional and statutory obligation to preserve the original surveillance footage from CPD in its entirety. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in the case. The footage that has been produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability of the CPD's video surveillance footage obtained from the Sally Port on January 29th. The Commonwealth has produced numerous video files without any way to verify their authenticity. That's what my last video addressed. Like, serious, guys. When we're done here, you need to go watch the last video I uploaded. Let me stick it in the chat and pin it for you. How do I do this? Are we even seeing a live stream over here yet? Show me live streams. Yep, we are. Cool. Let me pin this link for you. So when we're done here, you can go and watch it, because all of this is addressed. And even like from where we go from here, like, hey, where's the chat gone? There we go. Let me pin this. Pin it. Right. You have to go watch this video next, because I cover all of this and I go into several levels deep of how they can respond if Judge Bev refuses to dismiss at this point. So I'll be very surprised if we don't have a recusal motion, another recusal motion shortly. I guess they would want to see if this got dismissed before they have another go at recusing her. So she should have gone the last time she was recused, exactly. All right, James, thanks for joining us. So come back and watch us when you're done. Blink. Anyway. Yes. Anyway, let's get back to it. These video files include a file capturing the interior of the Sally Port garage with a 42-minute gap missing at the precise time that the feed would have showed an unobstructed view of the rear tail light of Miss Reed's 6,000-pound SUV as it entered the CPD Sally Port garage. In spite of the fact the Commonwealth claims the video surveillance feed is motion activated, the mid-trial production of an inverted video produced by the CPD in an attempt to save face for the gap in footage, which improperly depicts right as left and left as right, and falsely suggests that no one from law enforcement approached the right rear tail light, and a blurred out video that obstructs what would otherwise be another clear view of the right rear taillight of the SUV as it entered the Sally Port garage on January 29th. It is not a coincidence that none of the many cameras in the CPD Sally Port garage captured the condition of the right rear taillight upon its arrival at the CPD, and before the first pieces of taillight lens were materially recovered. Taillight lens material were recovered by law enforcement at 34 Fairview Road. The fact that the Commonwealth and its agents, the CPD, failed to preserve the footage in a forensically sound way and allowed critical evidence to be destroyed is not a coincidence, and goes to the heart of Miss Reed's defense and the credibility of some of the Commonwealth's most central witnesses. Even if ADA Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. We just said that, didn't we? Commonwealth versus Martin, 1988. Commonwealth versus Baldwin, 1982. Coles versus Whitley, 1995. There you go. Following the February preservation order, ADA Lally should have had a diligent prosecutor and a diligent prosecutor would have promptly notified CPD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. The certificate of compliance ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. Lally did anything but. Surprise, surprise. And the Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be viewed short of a dismissal. Yay! Yay! I totally agree. Thanks for joining us, Oz. And thanks for the thanks, and I love it. I'm glad everyone's getting something out of it. So, Laurie Jean, good to see you, mate. Lovely. Jake, thanks for joining us. Commit misconduct and then have it redacted on public documents. Yeah, exactly, Jake. Exactly. Glen Lake, Lally promise is weaker than a pinky. Right. Indeed it is. Just Irish. Thanks for dropping by. Thank you. So yeah, this is crazy, nuts, all of it, right? Continuing on. Okay, the statements by McCabe. A flagrant violation of its obligations under Brady and Rule 14. Commonwealth withheld May 10th exculpatory statement of McCabe in which she denied travelling to the personal residence of a first responding officer, Sergeant Lank, on January 30th. God, let's just skip through some of that. We know it. Obviously, they were required pursuant to Rule 14 obligation to disclose a false statement. Instead, they just write up another report to cover the false statement. Rule 14 requires all statements of persons the Commonwealth intends to call as witnesses, any facts of an exculpatory nature, the Commonwealth's decision to preemptively reveal impeachment evidence uncovered by defence to McCabe in advance of her trial testimony, and then withhold their exculpatory statements to law enforcement is a clear-cut violation of the Commonwealth's constitutional obligations under Brady and its progeny. All right, we're up to B. We need another coffee mouthful. The Commonwealth's egregious and repeated discovery and Brady violations require dismissal of this case with prejudice. Indeed. When the Commonwealth fails to provide its discovery obligations, the court has the ability to impose remedial sanctions. See Mass v. Crim 14C1, effective January 20, for failure to comply with any discovery order issued or imposed pursuant to this rule. Another sanction she never applied to the Commonwealth. Meanwhile, she's sanctioning the crap out of the defence. These are judicial bias. These are examples of judicial bias. They're examples of ruling in favour of the prosecution, which she's not supposed to do. She's meant to have impartiality. And so on. So here's all the case law. Sanford. Don't remember Sanford, 2011. Cronk. Don't remember Cronk, 1985. Don't remember that. These are all ones that I did not come up with. So this is great that they found a bunch like 1981. Dilworth. I think maybe Dilworth was maybe one that I found. There is no question that on failure of the Commonwealth to comply with a lawful discovery order, a judge may impose appropriate sanctions, which may include dismissal of the criminal charges. And she's not even violating in the way she's done with the defense. Dismissal is appropriate as a remedial sanction, as such a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. Dilworth. Carney. No, don't remember that one either. See, these guys are way better than me. They've pulled up way more than I found. Quoting Commonwealth versus Carney, 2010, also Cronk, and Commonwealth versus Lamb Hugh, 1984. Lamb Hugh 2. Nope, don't remember that one. Remember there was a couple of funny ones like that. I don't think that was it. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that prevents the possibility of a fair trial. Irremediable harm. Oh my God, there's so many more levels to this. Guys, when we're done, watch the last video. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the rights of defendants against the necessity for preserving society's interest in the administration of justice. Bridgman versus District Attorney for Suffolk District, 2017, also quoting Cronk. First, where the prosecutor fails to disclose evidence, the defendant is entitled to receive and the defendant is prejudiced by the failure. I think I just read that with the wrong emphasis. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should be allowed when the defendant can make a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. This comes from Cronk and Commonwealth versus White. We did find that one in discussing this same topic. Alternatively, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights, may give rise to presumptive justice. In such circumstances, dismissal would be appropriate if needed to create a climate adverse to repetition of that misconduct that would otherwise not exist. Bridgman, 2017, Lewin, 1989. They're doing good with the case law. They're doing freaking excellent with the case law. We have a question. Does Spanky get to argue against dismissal, or is it a decision purely for Bev? Can he argue against this? I think so. It's a motion to dismiss. Then he gets a motion that he can reply to the motion. And then it's up to judge whether she has like a little mini hearing for it or she just rules on it. So it's kind of up to her. But he does get to argue against the dismissal, but only at this stage just in a irredeemable. Thank you, Sassy. I got my tongue all tied. Redeemable, irredeemable. Gotcha. My tongue's like not happy today. Yeah. Thank you. I think I did know it was irredeemable. I'm tongue-tied. But I appreciate the corrections. Coney has lost all credibility, indeed, to satisfactorily perform judicial duties, full stop. Indeed. Didn't the Baldwin case get dismissed for less? Didn't it? For way less. Exactly. Right, what did I miss? Even a fool would know that evidence associated with a murder investigation should be preserved. Exactly. All right, let's continue. I forgot to tell you, we're on page 26. So we've covered some ground, but there's 147 pages in this. And I don't know. Let me have a look-ski over. Let's get the sidebar. Come on, sidebar, where are you? Don't hide the sidebar. Why are you hiding the sidebar? I want to see the pages. Show me the thumbnails. Here we go. We're on 26. Where's all the redactions going to start happening? Oh, we're not too far from the end. That's all right. So who wrote this? Alan Jackson, David Unetti, Robert Alessi. There you go. Served by Ms. Little. All right. We will get to page 36. We'll come back to the affidavits in support. Because I got some stuff. It's nearly daylight enough to go and do the stuffs I have to do. So I'll finish up these last pages. Where were we? Reading through all of this case law radio. So dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with its discovery violations. Given the extreme government misconduct in this case and the irreparable nature of the harm to Miss Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. The Commonwealth has failed to disclose evidence that it was obligated to disclose to Miss Reed, which has severely prejudiced her, such that a fair trial is not possible. Here, Miss Reed has been irreparably prejudiced by the Commonwealth's discovery violations in this case. The first trial resulted in a hung jury, precisely because this was a close case. Close case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Miss Reed was constitutionally and statutorily entitled to, the result of the trial may well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defence in a concerted effort to undermine the defence's ability to effectively confront and cross-examine Commonwealth seminal witnesses in this case, including Sergeant Buchanan, McCabe, and Higgins. U.S. Constitution Amendment 6. Moreover, the Commonwealth's continued production of exculpatory video footage, which has by definition been in the Commonwealth's possession since January 29th, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14 and Brady. It is well established that suppression by the prosecution of evidence favourable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution, quoting Brady versus Maryland, 1963. The Commonwealth may not withhold such evidence from the defence. To do so is not only a discovery violation under 14, but also a constitutional violation. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage from the CPD and failing to properly preserve this exculpatory evidence has irreparably harmed Miss Reed. To this day, the Commonwealth has not produced all of the video surveillance footage recorded at the CPD on January 29, 2022. Numerous camera angles and large swathes of time are missing. As a result, the Commonwealth's failure to appropriately image and preserve this evidence, video surveillance footage, which should have captured the condition of Miss Reed's right rear taillight at the time it was taken into police custody from multiple cameras at multiple angles, has now been destroyed forever. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29, 2022, the defence would have conclusive evidence that Miss Reed's taillight was cracked, not shattered, when it arrived at the conflicted CPD on January 29th. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barris testified, he observed earlier that day, that evidence would establish Miss Reed's innocence and be case ending for the Commonwealth. It should not be lost on this court that this video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. As a result, Miss Reed is left without the ability to forensically examine the CPD's DVR system to determine whether the many random clips produced by the Commonwealth in discovery has been altered, manipulated, or tampered with, and whether other clips have been destroyed. The Commonwealth's failure to preserve and produce this exculpatory evidence, which includes the destruction of all original native video surveillance footage and the accompanying log files, has irreparably harmed Miss Reed. There is no lesser sanction that can cure the Commonwealth's failures to preserve this evidence. Exclusion of the video surveillance footage at trial would undermine Miss Reed's defence because the footage itself is exculpatory. Indeed, the very nature of the evidence is such that its exclusion harms rather than helps Miss Reed. The exculpatory evidence to which Miss Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by dismissal of the case. Footnote 6 says, unsurprisingly, the Commonwealth is utterly unable to establish any chain of custody, and Judge Bev acknowledged that because she said to Miss Little the other day, what do you expect them to produce, like to create metadata evidence that isn't there or something along those lines? She was very sarcastic about it, but she more or less acknowledged that, this is missing. She knows it's missing. She knows that this is the result of it being missing, but she won't admit it. Considering how much you've read, you get a pass. Why, thank you, Sassy. Damnation, why wasn't I told you was live? I don't know, sweetie. Try checking whether you got notifications turned on. Sometimes you actually do have to go back in and reset your notifications. YouTube does silly shit like that. So, hey Vixie, thanks for joining us, and good morning, Michelle. Life artist, thank you. Hey Aussie, hey chat and mods. Linda, thanks for joining us. Let's have a look what I missed. I think the jury was hung because of the hanky-panky of the foreman. Right. Can they state Baldwin as case law? No, because Baldwin didn't happen at an appeal or a Supreme Court level. So appeals court, Supreme Court, and and SCOTUS, those are case law because those are the higher courts that make it case law, basically. Hi Trish, thanks for joining us. They have used an older Baldwin case. Are you referring to that? They did use a Baldwin case, but it's not the Alec Baldwin. It's not the Alec Baldwin case. So, defense should have. They should pound the fact that Miss Reed's SUV was alleged by the Commonwealth to be the murder weapon, and that they've lost the evidence of the murder weapon being the murder weapon. Absolutely. All right. So, let alone how explain it, how it had become inverted. Exactly. Unlike the other video surveillance obtained by MSP in this case, the CPD's video surveillance footage was never logged into evidence. There are no reports documenting the recovery of the evidence, and there is no documentation regarding its chain of custody. These are all really big issues for Bev. Not just because she hasn't sanctioned them, but because these are all appealable issues. I think they can actually stop the trial on the basis of most of this. Again, that video is pinned if you want to understand what I'm talking about there. Even if this court disagrees that Miss Reed has been irreparably harmed, of course she's going to disagree. It's Bev. Like, hello. The Commonwealth's misconduct gives rise to presumptive prejudice that warrants dismissal. The misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. These were not innocent mistakes. The repeated and flagrant discovery violations engaged in by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. Here, at trial, Lally, the Commonwealth, and its agents intentionally withheld video surveillance footage from January 29. The Commonwealth sprung inverted surveillance footage on the defence in the middle of trial in violation of Rule 14, as well as its certificate of compliance, and then it compounded the violations by attempting to perpetrate a fraud on this court and the jury. By knowingly eliciting false testimony from Sergeant Buchanan on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. Oh my God. Do you guys see why they pulled that stunt the other day? They pulled that stunt because they knew this was coming out. They were trying to get ahead of this. I mean, my previous assumptions that they were going to do something in retaliation for Karen's Ted Daniels interview, you can add that to the list. But they're doing the gaslighting thing where everything that they are doing wrong, they're blaming the defense of doing. The whole, the abusers do this, like the narcissistic abusers do this. Everything they're up to, they'll turn it back on you. That's what they're doing here. Trevor says, and the Commonwealth totally failed to preserve crucial video evidence of the condition of the murder weapon. Exactly. Exactamundo. Hey, Kevy. Whoops, I missed it. Sassy, my question is, when do they point out the misconduct of Bev? Well, after she denies this. So the pinned video will help you answer that. Kevy is awake, up and at 'em. Unfortunately, I feel Bev is going to deny it. Perhaps the defense will file interlocutory appeal when she does. Right, Trish. I forget which one this falls under, whether it's interlocutory appeal. I think this one does. This is a dismissal. So I think this one would fall under interlocutory appeal. Massachusetts got different standards. Again, watch the last video to answer that question. Higgins testified that he didn't talk to anyone. Yeah, exactly. Exactly, Vicky. Thanks for joining us, by the way. Yes. Baby's misconduct would come up. See, I think the way this will work, in the last video I said I'd be very surprised if they don't raise another motion to recuse Judge Bev. But in a way, also, I wouldn't be surprised because I think they've got a better chance of the federal court stepping in. If the federal court steps in for a motion to recuse Bev, then she can't oversee her own recusal motion. It will be taken out of her hands, essentially. So Bev's turn is coming. It's just not here because this is still in her court. So when we get up to appeals court and higher, state court, appeals court, state court, and federal court, that's when complaints about Bevy will come up. So, all right. Where were we? The inverted footage of Miss Reed's vehicle from this interior Sallyport camera was unquestionably a false account of the true facts, and the Commonwealth passed it off as an accurate depiction of the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the rear tail light. The Commonwealth's deliberate attempt to use discovery violations to its advantage in an effort to perpetrate a fraud on the jury is the precise type of conduct that requires dismissal. Precisely. Moreover, Lally and McLaughlin were caught red-handed with their pants down, withholding exculpatory information from the defense at the first trial. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligations under Brady and its progeny. Even after trial, Brennan located exculpatory video surveillance footage, which was withheld from the defense at the first trial, and established that Higgins made a phone call at 1:34 a.m. outside the CPD. This exculpatory impeachment material was never turned over to defense. Brennan, you lying liar from Lawyersville, blankety blank blank. The Commonwealth's repeated violations of its constitutional and statutory discovery obligations were calculated and intentional, and were done in an effort to secure a conviction at all costs rather than pursue the truth. Indeed, as discussed above, the Commonwealth's misconduct has resulted in a violation of Miss Reed's constitutional rights, so as to give rise to a presumptive prejudice. Discovery violations in this case constitute Brady violation, and thus violate Miss Reed's due process rights. Yes, we got the due process rights in there. Woo-hoo. To establish a violation of the rule of Brady versus Maryland as incorporated into Rule 14, the defendant must demonstrate upon review that evidence actually existed, which they've done, that evidence would have tended to exculpate him. They've done that, her rather, and the Commonwealth failed to disclose it upon proper request. Tick, tick, tick. Bam. Bang, bang. As discussed in Part 2A, all three prongs of the Brady inquiry are met with this case. That's pretty heavy too. I forgot that it had to be the three prongs of Brady. Forgot about that. No, I haven't mentioned that in any of my videos because I forgot about it. Given that these facts give rise to presumptive prejudice, and considering the need to create a climate adverse to repetition of that misconduct, quoting Bridgman 14, which is also quoting Lewin, this case should be dismissed. To allow this case to proceed to trial would create a climate in which these types of flagrant constitutional and statutory violations are regarded as permissible. Such an outcome cannot be tolerated by Auntie Bev. The Commonwealth's clear, repeated, and intentional failure to comply with discovery orders requires an appropriate remedy in this case, because the discovery violations concern a failure to produce and preserve exculpatory evidence, and because exclusion cannot remedy the violation. The only appropriate remedy is dismissal of the case because of the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, the withholding of material and exculpatory evidence, and failure to comply with court orders regarding discovery. Miss Reed's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. The defendant therefore respectfully requests this honourable court to order the case be dismissed with prejudice. A quick coffee break. We've only got a couple of pages left, most of which are redacted. So let's come over here. Where are we? Don't panic, Kev's here. Thank you for reading Well Dusted. I hope you have a great day. Dusted? Oh, I don't know what you mean by dusted. Have you got... Oh. Well, you're dusting. Gotcha. Now I get it. It's ridiculous in the first place, says Mandy Reardon, that a judge can make a decision regarding their own... I know, isn't it? Patently ridiculous. But you can, through the higher courts, intervene in that process, so she can't. Because they brought one in, they've kind of like technically exhausted the state's, the trial judge's ability to do that. So now a second one it's a completely different situation. Michelle, I'm about to drive home. Yay. Drive safe, my love. Bev won't dismiss this case. I know, Claire. Thanks for joining us. I agree. I don't think she will. It's horrible waiting to see if AJ will get booted. AJ won't get booted, and the ARCA guys won't get sanctioned. She can't do either of those things without... she can't do either of those things with any amount of plausible deniability. Let's put it that way. Again, the pinned video, when we're finished here, go watch it, because I do go into this in detail and why. Right, let's read the blankety blanks. Dismissal is the only appropriate remedy for the violation of Miss Reed's Sixth Amendment right to trial by an impartial jury. Additionally, dismissal of this case is also required to remedy the violation of Miss Reed's Sixth Amendment right to an impartial jury. Oh, shall I fill this in for you? Because Auntie Bev selected the jury 4-person. That on its own probably wouldn't have caused a partial jury. However, she also appointed Trooper Fanning to oversee the jury, which is expressly forbid under XYZ case law. I forget all the case law for it, but I did cover all of this in a previous video. So she's created a prejudice already because she's got a trooper overseeing them, and a trooper overseeing the jury is never admissible. I'm trying to think what the other points were. I know there was more points. But that led, right, her choice of jury person then led to votes that the jury made on counts 1 and 3 weren't communicated to her because her chosen jury foreperson failed to do it. So that works in the Commonwealth's favour. And so judge picking the jury foreperson now works in the Commonwealth's favour. Even though she's allowed to choose that jury foreperson, it becomes an issue when her choice does shit like that. So that's what all these blanks are essentially describing. Notably, a juror may never be dismissed because of their views on the case or for reasons having to do with their relationship with other jurors. Instead, jurors may only be dismissed for personal reasons to the juror that have nothing to do with those views on the case or the relationship with other jurors. See Commonwealth versus Tiscioni. I think that's how you say that. 2019. Commonwealth versus Rodriguez, 2005. Commonwealth versus Garcia, 2014. Commonwealth versus Pepicelli, 2007. Wow. This is a whole paragraph that I never got into, I don't think. Commonwealth versus Williams, 2021. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to an impartial jury. Oh my God, I know what this blank is here too. This blank here is to do with that juror getting dismissed and what the reason was that they gave, probably at sidebar, I'd say. A lot of these will be sidebar redactions. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to an impartial jury. United States versus Lafitte. United States versus Thomas. United States versus Camp. Ozamaro, Symington, and Abel. None of those I tripped over. Not a single one. The jury tampering, which is obviously to do with Trooper Fanning, such as this, is presumptively prejudicial. See Rema versus United States, and triggers a burden on the government to prove that tampering was harmless to the defendant. The Commonwealth cannot do so here. Blankety blank, as per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be in the best interests of justice. Judges can do this at any time during the trial process, although the procedural burden and standard vary at various stages. Post-empanelment, but pre-deliberation, if a judge is alerted to potential misconduct of or affecting the jurors, the judge first determines whether it was material, raises a serious question of possible prejudice. Under Commonwealth versus Tennyson, 2003, quoting Commonwealth versus Jackson, 1978. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Oh, Donna. I don't think Bev did that. I don't think she had any hearing into the alleged misconduct. I think she had a sidebar on it. Sidebar. She didn't do that, but she had a sidebar blankety blank blank blank. Ultimately, Miss Reed's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to dismissal of jurors. Those procedural protections were not provided here. Blankety blank blank blank. These constitutional violations, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Miss Reed and warrant dismissal of the case against her. Conclusion. For the above reasons, Miss Reed respectfully requests that this honourable court grant the defendant's motion to dismiss for extraordinary governmental misconduct with prejudice. although dismissal is required and appropriate under the circumstances, in the alternative, the defence seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to Lally, McLaughlin, Brennan, Tully, Rafferty, Proctor, Buchanan, Colleen Crawford, and other members of CPD, including Lieutenant Fanning. Bah, bah, bah. They left that one to last. Fanning didn't get his name redacted. All right. So, Jack Yannetti Alessi. Certificate of service, Eliza Little. Nice. So, we shall read some of these. I will book us another live stream. We only got 100 and how many pages? We only got 110 pages to go. But these are just everything in support. We got through the nuts and bolts of it. So thank you, Paul, obviously from UK. Thank you so much. And thank you, Mandy from UK. I can tell because it's GBP, which is pounds, isn't it? Great Britain pounds. Thank you so much for your super chat. Thank you, King Kevin. So, sassy, dun dun dun, Trooper Fanning. Hey, hey, bloody hell! Intimidating to have a trooper with a gun as a foreman, right? And on top of all of that, it's a BPD cop that was killed. Do you get what I'm saying? Like, you've got a dead cop, now you've got a cop overseeing the foreman, and it's like all that threat there. Like, you've got to look after the cop, and we got a cop here to make sure of it. Like, it's terrible. It's a terrible look. Especially a trooper that was connected. Exactly. Bloody hell. Do you happen to have an estimate on the time of your next live, or how long until? Let me see. I'm going to probably in the morning. Probably same time tomorrow. So whatever time it was for you when I started this, it'll be the same time in 24 hours. How's that? So today this is what I was doing while I was driving the other day. I was listening to the hearing. So some of it I actually did miss, and I do have to rewatch to catch the bits that I missed. But I was traveling interstate to go and get my excavator. I bought myself a little mini excavator so I can clear my block and actually start doing stuff. So yeah, we drove up there, bought a trailer, went and picked it up, and then went over to pick up the excavator and towed it all the way back here. It is currently sitting in my driveway in a box, in a crate. So I have to decrate that today and work out how to get it off the trailer. So yeah, tomorrow will be the rest of the affidavits. I don't know if anyone else is going to read the affidavits. Generally, most people are reading, the main substance of the arguments, so which we've done. But I don't know if some of them might. Melanie might read some of the affidavits. So thank you, Glenda, for the super sticker. Pair character looking at himself in the mirror. Thanks for being with you. Thanks for being you. Gotcha. Thank you so much, Glenda. Auntie Bear. Whoops. Great, Sassy. Hopefully we're good. I understand in maths that the judge is allowed to select the foreperson, but what baffles me is she chose the foreperson before they had random draw for alternates. Right, it baffled me too, but even the fact that she is allowed to, in Massachusetts, select the jury foreperson, it doesn't necessarily mean she should. So I have done a video on this in the last couple of days. I suggest you go and watch them all because I cover everything in this dismissal. I give you absolutely every possible outcome. How Judge Bev can possibly screw herself up in answering any of these points that have been argued here. And that is one of the things that I actually did cover. So she's allowed to, but she has created an issue now because that jury foreperson prevented them from asking her questions and then didn't bring back the 1 and 3 votes to her. So now she's responsible for not just choosing that foreperson. She's allowed to do that, but she's now responsible for the fact that that foreperson has been acting in favor of the Commonwealth. Anyway, I did do some deep dives on that. So, all right. Thanks, Aussie and mods. Have a great day. Where are we up to? An excavate, exactly. It is pretty cool because it's a tiny little one, and I'm actually a pretty tiny little person, so I'm excited. It's going to be like sitting on a vacuum cleaner, or like a ride-on lawnmower with a digger on it. So yes, it is pretty cool. I'm very excited about it. So thank you, Sassy. We shall book. I will book it in when we're done here. I will book it in so that you guys have got, notice for the next what time it's going to be. So right, so pinned in the description here is a video you need to go watch next. It's an hour long, and it's going to fill in some of the information that the defense isn't exactly addressing here, because it goes to different parts of the process. There's different levels of this process. This is just the trial court level. So that video in the description will help you understand all those different levels and what could happen from here, all the possibilities. So thank you everybody for tuning in, much appreciated. And we shall get on with the others tomorrow morning. So I think that's it. Ciao, everyone. Bye.